Welcome to Global Watch. Please subscribe and hit the bell icon for more breaking updates tonight. A rare moment of unity from the Supreme Court. A unanimous 9-0 ruling that's shaking the foundations of American rights. This decision, rooted in the First Amendment, is poised to reshape how the government interacts with your Second and Fourth Amendment protections. The case isn't just about legal theory, it's about the real balance of power between citizens and the state. What happens when officials try to silence voices they dislike? The court answered, the government cannot use its power to indirectly punish or suppress disfavored groups. This sets a new precedent, shielding Americans from so-called jawboning. When officials pressure private companies to do what the law won't allow, the implications are vast, touching gun rights, online privacy, and more. We'll break down what this historic ruling means for you, and how it could redefine debates about firearms and surveillance. The message is clear. The Constitution protects all viewpoints from government coercion. This principle now stands stronger than ever, forcing us to question how power is wielded from state offices to the White House. The story is complex, but its impact is direct and personal. We'll guide you through the legal battle, hear from those involved, and analyze the court's every move. This is more than a headline, it's a turning point. It could signal a new era of judicial scrutiny over government actions. Stay with us as we unpack a decision that will be debated for years to come. To grasp today's news, let's revisit the Bill of Rights. The Second Amendment. The right of the people to keep and bear arms shall not be infringed. Its meaning, individual or collective, has fueled debate for centuries. The Fourth Amendment protects us from unreasonable searches and seizures, establishing a right to privacy the government can't cross without a warrant. In the digital age, these protections now extend to emails and cell phone data. Landmark cases like Heller and Bruin affirmed individual gun rights, while Katz and Carpenter expanded privacy to digital life. The Supreme Court has continually adapted these amendments to new technologies and challenges. These precedents form the essential backdrop for understanding today's ruling. Our rights to bear arms and to privacy are not static, they evolve with the times. Today's decision is the latest chapter in that evolution. The Supreme Court's decision didn't emerge from nowhere. It's a response to growing concerns about government pressure on private actors. For years, officials have used their authority to nudge companies into cutting ties with certain groups or viewpoints, a practice called jawboning. Bantam Books, Verse, Sullivan, 1963, set the principle. The government can't use threats or intimidation to achieve censorship, it can impose directly. Recent years saw officials from both parties hinting at regulatory consequences for companies that didn't comply with their wishes. These weren't formal bans, but the implied threats were clear, chilling speech and association. The courts needed to clarify the line between persuasion and coercion. The Supreme Court recognized a pattern government power used to indirectly punish speech. This trend threatened constitutional protections for all, regardless of political affiliation. The justices saw the danger and prepared to make a decisive, unified statement. That moment has now arrived. The case at the center, NRA vs. Vullo, began in New York after the Parkland shooting. Maria Vullo, then head of New York's Department of Financial Services, allegedly pressured banks and insurers to cut ties with the NRA. The NRA claimed this was a campaign to cripple their finances and silence their advocacy. Vullo sent guidance letters urging companies to consider the risks of doing business with the NRA, and allegedly offered regulatory leniency in exchange for dropping NRA programs. Lower courts were split. One allowed the lawsuit, another said Vullo's actions were permissible government speech. The Supreme Court took the case to resolve whether this was legitimate regulation or unconstitutional coercion. The stakes were high, not just for the NRA, but for any advocacy group. If officials could pressure banks to cut off one group, any group could be targeted. Even the ACLU, often at odds with the NRA, supported the gun rights group, arguing that regulatory power shouldn't be used to blacklist speakers. This unlikely alliance underscored the fundamental principles at stake. The case transcended partisan politics. The question, can the government use its power to silence opponents by pressuring private companies? The Supreme Court was ready to answer, and the answer would have sweeping consequences. On September 19, 2025, the Supreme Court ruled 9-0 for the NRA, Justice Sonia Sotomayor, writing for the court, made the message clear: government officials can express their views, but cannot use threats or coercion to suppress speech. The ruling didn't decide Vullo's guilt, but allowed the NRA's lawsuit to proceed, drawing a sharp line between persuasion and coercion. A government official cannot do indirectly what she is prohibited from doing directly, Sotomayor wrote. If the government can't pass a law to shut down a group, it can't pressure companies to do it for them. The court found that Vullo's alleged actions suggested a campaign of coercion against the NRA's advocacy. The unanimity was striking. Liberal and conservative justices agreed. Protecting speech from government coercion is fundamental. Sotomayor's authorship, despite her history on gun control, emphasized that this was about free speech, not guns. The decision revived and modernized the Bantam Book's precedent for today's regulatory landscape. Courts must now examine the context of officials' actions. Are they governing or punishing viewpoints? This framework gives advocacy groups a stronger legal tool to fight government overreach. The marketplace of ideas, the court said, must remain free from the heavy hand of the state. The ruling's impact will be felt far beyond this case. Though NRA versus Vullo focused on the First Amendment, its logic ripples out to other rights, especially the Second and Fourth Amendments. The core: government can't use indirect pressure to do what the Constitution forbids directly. This doctrine now has new teeth. For gun rights, if officials pressure banks to cut off firearms businesses, that could now be challenged as unconstitutional coercion. The same applies to privacy. If officials pressure tech companies to hand over data without a warrant, that's now on shaky ground. The ruling forces officials to be careful. Persuasion is allowed, threats are not. Private companies now have legal grounds to resist coercive government requests. This creates a stronger buffer for our liberties. Our rights to speak, bear arms, and protect our digital lives are now better shielded from backroom government pressure. The precedent fundamentally changes the dynamic between government, industry, and individual rights. The Vullo decision's impact on the Second Amendment is immediate. It blocks a growing strategy pressuring banks and insurers to deplatform the firearms industry. Before, officials could claim they were just advocating for public safety. Now, if that advocacy is backed by threats, it's unconstitutional. Firearm businesses denied services can now sue, arguing the government coerced the banks. State laws protecting the gun industry now have a powerful constitutional foundation. Discriminating against a group for exercising a constitutional right is illegal if the government is behind it. Expect new litigation as gun rights groups scrutinize regulators' actions. The ruling demands transparency and accountability from government agencies. The right to bear arms can't be choked off by cutting access to the modern economy. The Vullo ruling's effect on privacy is profound. Our private data lives on tech company servers, not in desk drawers. The government has often pressured companies for access, sometimes without warrants. Now tech companies can resist, arguing that complying under duress is unconstitutional. Privacy advocates can challenge not just data seizures, but the coercive practices that lead to them. The focus shifts to government conduct. Is it using power to bypass the Fourth Amendment? Law enforcement may have to rely more on warrants, less on informal pressure. Companies gain a constitutional shield to protect user data. In a digital age, this decision updates our privacy protections for the realities of modern life. The government must respect the rule of law, even in cyberspace. The Supreme Court's unanimous ruling in NRA versus Vullo is more than a single case. It's a new standard for government power. Officials, regardless of party, cannot use state power to indirectly silence or punish opponents. This principle now defends not just speech, but gun rights and privacy. Agencies must ensure their actions are persuasive, not coercive. Advocacy groups have a potent new tool to challenge overreach. Expect lawsuits over financial deplatforming and warrantless data sharing. The debates over guns and privacy will continue, but now, in the open, not behind closed doors. The Constitution's principles remain central to our most pressing debates. The rule of law applies to everyone, especially those in power. Thank you for watching. Let us know your thoughts below, and stay tuned for more analysis.